and he raises it, and he shoots the victim in the face. The bullet's going to go in above the left eyebrow, and it's going to remain in his head, where an autopsy pulls it out. The firearm is so close that there's actually stippling and burned particles on the victim's face.
And for the defense, Edgecombe's attorney, Beverly Lamar, delivered the opening statement and described the Clearmans as the clear aggressors.
The evidence is going to show in this case that the Clearmans, well, specifically Jason Clearman, yelled out, "Get the out the road!" And it's at that point that Mr. Edgecombe got very upset. It's a very offensive word. Now, Mr. Edgecombe will testify and explain that as a bicyclist, this is not the first time that he's almost been struck by a vehicle. That is not what bothered him. Mr. Edgecombe is going to explain it's the use of that racial slur which set him over the top. So he's not just going to get food and just find a car and just go punch somebody. He goes to the car, he asks Mr. Clearman, "Were you talking to me?" Mr. Clearman says, "Yes, racial slur, I was talking to you." And that's when Mr. Edgecombe punches Mr. Clearman. The evidence in this case is going to show they chased Mr. Edgecombe. The evidence is going to show in this case, Mr. Clearman says to his wife, "Follow him." And Ms. Clearman, no objection. She does exactly what her husband says, and she follows Mr. Edgecombe. Mr. Edgecombe, when he testifies, he's going to explain to you that the last thing he was thinking about when a gunshot goes off, when he's trying to avoid being tackled by a man that's over 60 pounds heavier than him, was what he's going to do a month from now, or what he's going to do 3 months or 4 months from this very moment, or as the state talks about the 6 months, this was the last thing he was thinking about what he's going to do 6 months at this point. That's what the evidence is going to show. He was thinking about how he's going to get home to his family at this time. That's what the evidence is going to show.
Court TV legal correspondent Julia Janae is joining us live tonight from Milwaukee, Wisconsin. All right, Julia, opening statements were very, very compelling today, particularly the defense. So fill us in first on the state's approach in openings.
Michael, there was high energy inside of that courtroom during these opening statements. And the prosecution, they were succinct but dynamic. Huebner really laid things out for this jury in a compelling but concise way. He only took about 10 minutes to tell this entire story, really getting in and getting out, just explaining what happened, the initial confrontation, the words that he said was an expletive, and the word idiot. He does not say in his openings that any kind of racial slurs were used. And then he focuses most of the opening statements on what the defendant did afterward. We know that they are telling this jury this shows he knew he was guilty because he walked over the victim. He left with his bike. He did not return for 6 months, went on the run. So I noticed a lot of that being focused on by this prosecution and paid attention to by this jury.
Absolutely. Now, the defense, Julia, they really went after what they claim is a narrative that has been out there about this case, trying to switch that around a little bit. And they actually revealed some startling details about this case. As I listened in, I was like, a lot of us were like, wow, that never heard that before. Fill us in on some of that.
They did, and I thought Beverly Lamar, he really took head on the problems with the case. One being that punch. The prosecution did a great job of explaining to this jury how serious this punch was. And then that video was shown later to this jury. And what led up to it, the defense said, was this racial slur that was being hurled at his client. And that, yes, he did come up on the side of this vehicle and he did punch the victim in this case, and that it was wrong, that he should not have done it, he should have handled it differently, that he should have called police. But then he started to talk about the alleged victim in this case, Jason Clearman, talking about the fact that he was someone who had just come from a night of drinking heavily with his wife, that his blood alcohol content was 1.5 times over the legal limit, that he had THC or form of marijuana inside of his system at the time. And then the defense took aim at his wife, at the victim's wife, Evangelina Clearman, who was driving that SUV, saying that she didn't react the way that you would expect a grieving wife to act after witnessing her husband being shot and killed, that she didn't call 911, that she didn't apply pressure to any wounds or try to administer anything life-saving, but rather that she was going in and out of their car, that she was taking things out of his pockets. And interesting that he kept bringing up the word pockets, even though it's so difficult to see in that surveillance video. But this jury was then shown something that was in Clearman's pocket that was very important for this jury to see, and that's a knife that he had in his pocket that was found by first responders once they looked inside his pocket. The prosecution says Clearman didn't have anything in his hands at the time of this confrontation, but the defense says there was something in his hand. They don't go so far as to say it was the knife, but they did raise questions for this jury, and I noticed some of them looking at each other as if to say that is a question we want answers to.
Absolutely. We all want answers to those particular questions. All right, quickly, I know I noticed it. Tell us if you noticed anything different about the defendant today.
Well, clearly his appearance is markedly different from what we see in the mugshot. Today he was very clean cut. I noticed him looking very somber at the defense table, trying often to sit very tall, but he really comes across as a meek person sitting there next to his attorney, who is more bombastic in his style. Clearly, just from what we've seen in the mugshot, his hair looks different, but what he looks like in the courtroom is much more closely to the pictures that we've seen of him with his family. The defense gave us many pictures of this man with his 5 children, and that's how he looks on a regular basis. So it raised the question of whether or not that picture that we've seen in the mugshot, where his hair is really long, his beard seems very unkempt, that may be a result of him being on the run for 6 months. And according to his attorneys, he was trying to find representation. According to prosecution, he was on the lam and not planning to turn himself in ever.
Yeah, 2 very different looks for the defendant there. All right, Julia Janae, thank you so much for that report. Truly appreciate it. It is time now to bring in my think tank for tonight. Joining me tonight in Atlanta, Georgia, criminal defense attorney Eklund Mercy. In Los Angeles, California, former federal prosecutor Nima Rahmani. And in Phoenix, Arizona, criminal defense attorney and the attorney who represented Jodi Arias and the author of the book series Trapped with Ms. Arias, Kirk Nurmi. Thanks to all of you for joining me tonight. This is a true think tank, so I really appreciate you being here with me. So, Eklund, I have to start with you. First and foremost, what was your take on the openings? I thought they hit all the points they needed to hit and did a fantastic job. Love to get your thoughts.
Oh my God, Michael, I loved it. I loved all of it. I love the defense's opening. I love it when they don't play small, they play big. He had a theme, but unfortunately I'm not pro-prosecution, but the prosecutor kind of shot himself in the foot saying the firearm was so close. That meant that the alleged victim was really that close to the defendant. So I love it. I love just the fact that they are putting it in perspective for Edgecombe. You have the pictures to show that his hair is usually this way, and also to argue I see that people may have problems with his hair and he's been on the run, but he just killed a white man in Wisconsin. He is literally police could have killed, anybody could have killed him at that point. So I am interested to see how this attorney is going to make it make sense, how it's going to really close full circle. I can't wait.
Yeah, Kirk Nurmi, she's exactly right, and that was going to be my next question. Both sides seems to be using this idea that the gun was close to their advantage. And when the prosecutor was talking about it, he seemed to be suggesting that that would help their case somehow, that it was so close to him. He shot him point blank range. And of course, the defense made that same claim. Well, he was so close, he had to shoot him within inches of his face. So what are your thoughts on that particular fact and who it might help?
I think that ultimately helps the defense, Michael, because he was so close. He was charging, right? And we go back to this whole idea, we talk about it, put it in the context as well of the knife, right? Whether it was moved by the wife or not. Did this man really run out of the car after being punched and have a knife in his pocket and not draw it? What was Mr. Clearman expecting to do, right? And so I think that all ties into it. And really it favors the defense, because if they can make an assertion that he had the knife, Mr. Clearman had the knife in his hand, that actually the defendant acted with great restraint because he didn't shoot him until he absolutely had to. So to me, that's a fact that favors the defense strongly.
Yeah, we're going to have to look closely at where exactly that knife was and what he might have had in his hand. There was an allusion to it by the defense. Nemo Rahmani, the defense also brought in something regarding the N-word, and that this was no ordinary interaction. Things like that happen all the time while you're riding a bike on the road, or happen to this defendant. But this one was sparked by the use of the N-word. I want to get your thoughts on the use of the N-word and whether that or how that will play into the case.
Michael, it's very important. It's the most disgusting racial slur one can utter. And given the history of what African Americans have suffered in this country, it really dirties up the victim in this case. It's someone who's drunk, someone who has a knife, and who's uttering racial slurs. So paints a very damning picture. I think the defense did a very good job in their opening statement. I think this is a very strong defense case. And I think the prosecution needed to own up to that fact, or at least address it in their opening statement and say, no, that's not true. Because right now, I think the defense is controlling the narrative. You know, week in and week out, we come here on Court TV and we track these cases, and I say that the evidence is overwhelming and this is a strong prosecution case. But I can see why Eklund and Kirk are so excited about this one, because this one, I think, could go either way.
Yeah, this is certainly going to be interesting. And I think that the prosecution did suggest that he didn't use the N-word, that he said an expletive, idiot, something along that line, did not use the N-word. That's their claim. And they're calling a number of witnesses. So I'm sure folks will testify. The wife's going to take the stand. I'm sure she'll say what he said as well. All right, think tank, stand by. You're going to stay with us. And when we come back, we're going to take you into the courtroom for another Wisconsin case. It is day 8 of Chandler Halderson's trial, and it wrapped up today. The state is still going. We'll have the details next. Keep it right here on Court TV. We are in day 8 of Chandler Halderson's murder trial. The 22-year-old defendant is accused of murdering and dismembering his parents, Bart and Krista Halderson, in July of last year. The prosecution is expected to rest their case tomorrow, and today they put the spotlight on the defendant himself and his elaborate web of lies. Now, it's clear that this case is about how the defendant murdered his parents and the great lengths he went to attempt to cover it up. And I say attempt because it didn't go well. But just as important to the state's case is Halderson's web of lies, because prosecutors seem to be suggesting they are the motive for the murders. And today was all about bringing into focus just how involved these web of lies were and how they came to light. Before the state rested, they called Omar Jobe, an enrollment coordinator at Madison College, where Chandler Halderson had told his parents he was enrolled. Jobe testified that Bart Halderson called him about his son's enrollment status, leading to the discovery that perhaps Chandler had been less than truthful about his status as a student.
I don't see that you were admitted.
I'm having a hard time hearing you.
So I don't see that you were admitted in any program.
So you said they were, the IT degree is in there, right?
No, those are just classes. Like you took general education classes and then the IT classes. You might have just took the classes but not be in the program.
Does the internship from the spring show up in there?
entrance from the spring of what year? I can go back.
Oh, this year, 2021. So winter. Yeah, you do spring. Yeah. No.
All right, still with me, criminal defense attorney Eklund Mercy, former federal prosecutor Nima Rahmani, and criminal defense attorney Kirk Nurmi. And Nima, I'll start with you. Means and opportunity haven't been a problem at all for the state. They seem to have or be suggesting that this is in fact the motive. We know they don't need motive, but juries like to hear it, and this is what they're presenting. Does this hurt their case at all?
It doesn't. And Michael, you nailed it. I mean, the jurors are going to want to know what is going to prompt a son to kill his own parents, shoot them, try to burn the bodies, dismember them, spread them across 2 different places, and tell this elaborate web of lies to everyone, law enforcement, the media, friends and family members. So I think it's important for the prosecution to have a story to explain to the jurors why someone would engage in such a heinous crime like this.
You know, Eklund, as I look online and folks commenting on this case, what I've found is that a lot of people are taking these lies and really thinking badly about the defendant. It's sort of adding to this whole thing, almost more so than the other evidence about all the other things he's done, all the horrible, horrible things he's done. These lies really seem to have folks thinking this guy had some real problems. So it actually has that dual effect. It not only provides the motive, but really paints the defendant in a really terrible light.
I know young boys like him, and they lie often. You know, lies are normal for teenagers, for young men who have to deal with their parents. So I don't see that as, you know, really damaging. Even with the situation with school, him not being enrolled in school, I don't see how a person's whole appendage should be in another state because you're not actually enrolled. So I think it's kind of weak. And I think that the jury's going to want more. I'm shocked as defense that a motion for a psychological evaluation wasn't done, because that would be my defense, because nobody normal just puts pieces of persons in different states, especially their parents. So I think that that's the thing. Like, mental health is real, and I do not see, I don't see how a normal person can mutilate their parents and that be considered normal. And the reasoning is because they weren't enrolled in school. I don't see that happening.
You know, Kirk, Eklund is exactly right. I mean, one of the things I've said to a lot of the folks around here at Court TV is that it really isn't that odd for a teenager or a young man in his early 20s. And, you know, kids are growing up slower these days. So you're 22 or whatever, but you're still younger in years. It sounds like you spent a lot of time playing video games. So not uncommon. And to talk about that as the motive for the murder does seem odd. Your thoughts on this idea that perhaps, you know, that particular motive might be a bit flimsy?
Well, here's what I would say to that, because you could be right. You know, you have young men lying, young women lying, those kind of things, misrepresenting themselves. But if we look at the way the state has presented this case, and we look at all the lies, we understand that his whole identity, Mr. Halderson's identity, was built on this web of lies. Did he have anything else but these lies in his life? I mean, he had no job. He wasn't going to school. You know, he had a girlfriend that cared about him, but that was about it. But it was all based on lies. His whole identity was a lie. So I think I'm going to agree with Nima here that this does serve as motive, because you think about it, when that lies are going to be exposed, when his parents have figured him out, that's going to rip away his whole identity, who he is, his entire life, probably his girlfriend, everything he cares about. And that does make it a motive. That's a little different than boosting up your salary or something to get a date. It's a lot different. It's his whole identity.
Yeah, you're exactly right. And, you know, for me, throughout this case, the outlier has been the girlfriend. Generally, kids like that don't have girlfriends, especially one as attractive as his girlfriend. And maybe he just didn't want her to find out. That was the one area where I'm like, this seems a little different. But anyway, I think you're exactly right. I think it's more than enough, you know, when you look at all the evidence that the state has presented thus far. All right, think tank, stand by, please. We do have to take a quick break right now. But here's a look at what's still ahead on Closing Arguments. On the docket tonight, Michael Mosley is charged with murder after allegedly stabbing 2 men to death in a bar fight. We have a preview of the trial.
There is absolutely nothing that Clayton Betharda and Paul Trapini and AJ did to bring this on themselves.
Plus, a new law applying to transgender students in Texas. It says public school student athletes must compete in sports agreeing with their biological sex at birth. So tonight we ask you, the 13th juror, does this new law help or hurt student athletes? On the docket tonight is the deadly bar fight trial. Defendant Michael Mosley is accused of stabbing and killing 2 men and injuring a third outside a Nashville bar. And we have a look at some of the background on this case. Police say this video from inside the Dogwood Bar in Nashville, Tennessee, shows the beginning of an encounter that would end with 2 people dead and a third man wounded. According to investigators, a fight over a woman spilled out of the bar and onto the street, where Clayton Bethard, 22, and Paul Trapini, 21 years old, were stabbed to death.
I think it was such a shock to everybody that this could actually happen.
These were good boys, and they were defending their friend.
Clayton Bethard was a standout college athlete and played most recently for Long Island University. His coach tweeted, "His love of life, people, especially his teammates, was a shining light on our program." Clayton's brother, CJ Bethard, a backup quarterback for the San Francisco 49ers, took to his Instagram account to write, "Clay has the biggest heart of anyone that I have ever known." Paul Trapini III was captain of the high school football team. He attended Rhodes College in Memphis and was exploring law school before he died. The accused killer is Michael Mosley, and he's been charged with 2 counts of first-degree murder.
There is absolutely nothing that Clayton Betharda and Paul Trapini and AJ did to bring this on themselves.
Prosecutors say Mosley has a criminal history that includes this 2017 assault captured on surveillance video. Police say Mosley went into this Nashville Walmart looking for someone. When he found her, he knocked her to the floor and attacked her, kicking and punching the woman repeatedly. When customers started to approach, Mosley ran from the scene and out the front door. He was later arrested.
Somebody just hit me in the eye. So, I lost my sight and I was covering in it. He started throwing me and kicking me.
This is Molly Baker. She says he stabbed her in the eye with a key during the attack. Police suggest Mosley attacked her as payback. She and her husband are accused of murder in the shooting death of Mosley's stepbrother in 2016. Mosley was free on bond and facing criminal charges in connection with the attack when the fatal stabbings occurred. Mosley's defense attorney says his criminal past should not play a role in the murder case against him and believes video evidence will show his client was defending himself.
A person has a right to defend themselves if they think that they are in danger of serious bodily injury or death.
While Mosley remains in jail until his trial, friends and family members mourn their loss.
Lord, thank you for Paul and Clay.
And a survivor waits for justice. All right, still with me, criminal defense attorney Eklund Mercy, former federal prosecutor Nima Rahmani, and criminal defense attorney Kirk Nurmi. Kirk, I'm going to start with you on this one because this, again, is another self-defense case, but you got the guy claiming self-defense being someone who has a really long track record of violence and particularly revenge-type violence. Doesn't seem to like whenever he feels disrespected or things don't go his way. How is all that going to play into this trial?
Well, the big decision is going to be, is that going to come into this trial, right? Is these other acts evidence going to come in to show that he has a propensity? So once we get past this preliminary phase, once the evidence starts coming forward, I think that's going to be one of the biggest issues in the trial, because when we talk about this other act evidence to prove that he, in fact, was the initial aggressor, that ruling is going to be the game changer for this trial, because if the jury knows about that past and then we hear from the victim, it's going to be much easier to convict the defendant in this case.
Yeah, and he's got a background. Quickly, you saw him attacking the woman in Walmart. Well, that woman and her boyfriend, the one you saw sitting on the couch with her, were charged with killing his stepbrother. So he was getting back at them. And then later on, the husband sitting on the couch, he attacks him. They end up in the same jail somehow. He ends up attacking him in jail as well. And you know, Nima, he was allowed to leave jail. He had a long history of convictions for assault, felony assault, armed robbery, that jail brawl. They eventually had to let him out because the jail was overcrowded. So he shouldn't have even been on the street. So that's a major issue in this case. It's not going to come in, of course, at trial, but the fact that he had that background and was able to get out on bail, I mean, that's the type of thing that, you know, is looking for trouble.
No, I agree, Michael, and this is a huge issue in this country with bail reform, and Eklund's probably not going to want to hear this, but, you know, you have folks that, whether there's delays because of COVID or court closures or prosecutors that really want to change our cash bail system, there's violent folks who are out on the street and they engage in this type of action, and lo and behold, we're dealing with a murder trial. But I also agree with Kirk that, you know, prior bad acts evidence, it's so extremely powerful. And if Mosley's attorneys have to get up there and defend the attack on Baker, particularly a woman, they're going to be on the defense. They want to change the narrative. And we know how important the narrative is in these self-defense cases, that he's one guy. There are these three bigger jocks that surround him because he allegedly talked to a woman. So that's a very different story to tell the jurors than one explaining an attack on a woman at a Walmart.
Yeah, Eklund Mercy, Nima makes a great point. You know, the deck is stacked against Michael Mosley. He's got this horrible background, but you do have three athletes who are going after him. It's 3 against 1. I mean, that kind of levels the playing field a little bit in that courtroom, do you think?
No, so this is why jury selection is so important. So if you ever went away to school, you'll know that it's like a tale as old as Animal House. You have the town, the locals, the townies versus the college students. And there's an animosity that no one can explain. And you can actually see that. So if the prosecutor actually just pinpoints to that, you have two, you know, golden boys, they're college, they're, you know, stud college, they are there. They are the antithesis of what this defendant is. It probably riled up some emotions and he got a little bit more, you know, and he got violent. With regards to that bond situation, here's the issue. So he should not have been given bond. And the thing with the jail system is that we have people who are still in jail for minor misdemeanors. But when you are fighting in the jail, you stay there. So that's a situation with the sheriff. And that's a problem. So I think that the victim's family should be finding some civil attorneys because he should not have been left out. But I really do think that it's an uphill battle. If this was my client, I would definitely have him plead.
Yeah, and we're watching video there of that fight. We have the whole video there, and it was really tragic. It was just not a good thing, and the fact that he was out just really shocked me. I remember doing research on the case and realizing, I'm saying, boy, this guy should never have been on the street. All right, now we will continue, of course, to track this case right here at Court TV. Right now, there's a hearing scheduled for tomorrow, January 20th, and the trial date is set for March 28th. All right, guys, it is time now for a short break, but when we come back, we'll be taking a look at a new law in Texas that says public school student athletes must compete in sports aligning with their biological sex at birth. Break it all down when we come back, so keep it right here on your front row seat to justice. A new law in Texas takes aim at transgender athletes competing in sports under their stated sex. Now, the new law says that public school student athletes must compete in sports aligning with their biological sex at birth, leading many to wonder, is this the right move to protect all kids, or is this discrimination? Austin Walker with our affiliate KXXV has more.
For many, sports are a distraction, whether you're swinging a bat or throwing a ball. It's a time to step away from the problems you're facing.
It teaches you how to be part of a team, how to work towards a common goal.
But for Tori Brumbaugh, that philosophy is going away for some.
We all have to deal with the repercussions of this.
Tuesday, House Bill 25 becomes law. The law requires public school students to compete in UIL sports based on their biological sex. A law Brumbaugh says directly impacts transgender athletes.
Just to see their willingness to come after children, to attack children, is like, from a citizen of the state, is very upsetting. And as a person of the community that's directly affecting, it's very depressing. It's heartbreaking.
All right, we are now live.
Tuesday morning, advocates of the new law met to celebrate its passing.
It's great to be here. This is an exciting day.
The panel saying a transgender woman, born male then transitioned to female, has a clear advantage over female-born and participating athletes because of the biology. One North Texas coach says this law overall protects female sports, ones her daughter participates in.
That ensures every school-age girl athlete no longer has to worry about getting replaced by a male on the track, in the pool, on a court, or on the field.
But for people like Brumbaugh,
it's depressing.
Leaving her at a loss, thinking of children like her.
It was actually hard.
She says a disadvantage arises for children who have omitted their born puberty and have gone on hormone blockers.
A couple of years ago, they had a transmasculine kid up in Euless who was forced to wrestle. He was forced to wrestle girls because the school district rule was, even though that he was taking testosterone, because he has a female on his birth certificate, because of testosterone, he demolished them.
So while one side says they're here to protect children, another group of people say this law is damaging. Leaving people like Brumbaugh concerned, is the simple pleasure of competing in sports going away?
Now, according to the ACLU, in 2020, 18 states introduced this kind of legislation. In 2021, 31 states added their names to the list. In January of last year, the Biden administration issued an executive order supporting current law on the issue. The order was titled Preventing and Combating Discrimination Based on Gender Identity or Sexual Orientation. In part, it says, children should be able to learn without worrying about whether they will be denied access to the restroom, the locker room, or school sports. The order makes no new law, but simply expresses the administration's anti-discrimination stance in support of the current protections afforded by the Constitution as interpreted by the Supreme Court. And the Supreme Court did take on this issue in 2019 in Bostock versus Clayton County. And in that case, the court ruled under Title IX of the Civil Rights Act of 1964, it is illegal for an employer to discriminate against someone for their merely being gay or transgender in an employment or education setting. Now, how this applies to interscholastic sports has been debated ever since, and hence these laws. All right, still with me, criminal defense attorney Eklund Mercy, former federal prosecutor Nima Rahmani, and criminal defense attorney Kirk Nurmi. Eklund, I'll start with you. Your thoughts on this issue. This is an extremely complicated issue. But again, the court has ruled one way, but should it apply to sports, education? I mean, it's such a difficult thing.
I'm sorry, I gotta say, this is stupid. And the timing is stupid. Because you know what's harmful to athletes? School shootings. What's harmful to athletes? COVID. What's harmful to athletes? HIV and chlamydia. It is not, this is not the time. I think it's very political to put this is the law that you want to pass while we're in a pandemic during intramural sports where all these other issues are presenting themselves. I think it's stupid. I'm sorry, that's it.
All right, Nima, I'd love to get to you. I mean, I hear you, and I totally hear you. I mean, the whole thing could be tone deaf, but at the end of the day, Nima, it's a serious legal issue. It presents serious legal questions, and one of the things that I found out in researching this story is that, this has been going on for a while, and it hasn't really changed the landscape of women's sports. And they're saying that the outcomes for the transgender kids is very positive, that if you bar them from things like sports, it really has a negative effect on their lives.
Michael, we're talking about politics, but this is what the law is. The Civil Rights Act prohibits discrimination based on sex. The Supreme Court has held that applies to gender identity. That's clear. It applies in public schools, it applies in the workplace. So this law is unlawful. It will be litigated and it will be overturned. And that's really what civil rights are for, to protect the minority, to protect transgender students, to protect religious, ethnic, racial minorities. So for folks who are in the majority to say that this is going to somehow undermine women's sports, I think that runs afoul of the law and really is discriminating against these transgender athletes who need the law's protections more than anyone. And that is the majority conservative Supreme Court that held that the Civil Rights Act protects transgender students and transgender employees.
You're absolutely right. Kirk Nurmi, did the law go too far?
I think so. And, you know, Michael, you said it was a complicated issue. To me, it's not that complicated because if we look at the real purpose of sports in high school, in the high school setting, it's not the competition, it's the learning that derives from that competition. And ultimately, when we're denying certain classifications of people that are set by arbitrarily by a law that probably stands against the Constitution, we're denying ultimately those people the opportunity to participate in that learning environment. And ultimately, the other people that are, quote unquote, allowed to participate, their learning is inhibited as well because they're not exposed to the diversity and the lessons that playing alongside those people could take. So I hope Nima's right, and I hope the Supreme Court strikes down this law because it does seem pretty clear the purpose of these sports in these schools is for a learning environment for all, and that is undercut if you discriminate.
You know, Kirk Nurmi, extremely well said, and I couldn't agree more. This is an opportunity for everyone to learn inclusiveness and learn from each other. That's what sports is really all about. All right, I want to give a big thank you to my think tank tonight, Eklund Mercy, Nima Rahmani, and Kirk Nurmi. Thank you so much for being with me tonight. Truly appreciate it. We always appreciate your expertise. All right, guys, it is time now for a short break, but when we come back, we'll hear from you, the 13th juror. What do you think of this new Texas law? Does it help or hurt student athletes? Your verdict when we return.
It teaches you how to be part of a team, how to work towards a common goal. We all have to deal with the repercussions of this.
Yeah, fair enough. It is time now to hear from you, the 13th juror. And today we asked you about a new law applying to transgender students in Texas. It says public school student athletes must compete in sports aligning with their biological sex at birth. So tonight we ask you, the 13th juror, does the new law help or hurt student athletes? All right, our comment of the day is from Ken Cass on Twitter. Ken writes, look, I'm in the LGBTQ community myself, and I have to say I agree with this, as there are different strengths and weaknesses in the sexes that can be either advantageous or disadvantageous. This is strictly about biological fairness. I love sports, yet don't want to see it change. And absolutely, he's true, and there's all kinds of issues in the NCAA. For instance, they make athletes have hormone therapy for a year before they can compete, things of that nature to try to even the playing field. But it is a definite issue. Our next comment is from Jim Borders. Jim says, it should be up to the coach and what type of sport. For example, baseball and football, why not? Swimming and tennis, not so much. Team sports are not the same as individual sports, my opinion. And that's an interesting opinion because I do think the sport is an issue. But one of the things that came up was that this might disadvantage black athletes because they tend to have issues, people thinking that they are too muscular, let's say black females versus regular females or white females. So, you know, it's just an interesting situation. Anyway, all right, really interesting issue. We'll keep on top of that one. We do have to step aside now for a quick break. When we return, our investigators will join us and take a look at a story out of Los Angeles, California, where a young woman was stabbed to death while working alone at a luxury furniture store. All that and more when we come back. Keep it right here on your front row seat for Justice. In Milwaukee, Wisconsin, the jury has been seated in the case of a man accused of killing an immigration attorney in September of 2020. Tonight, we look at the opening statements in the case against Theodore Edgecombe.
We're going to talk about the good, the bad, and the ugly.
In Los Angeles, California, a UCLA graduate student is stabbed to death while she's working at a furniture store. Authorities now have a suspect in custody. Tonight, our experts weigh in on the next step in the investigation.
A citizen who was coming into the store, a customer, found Brianna lying on the ground, lifeless, covered in blood.
In tonight's Unsolved Case File, in Tulsa County, Oklahoma.